Public interest litigation. Listen, litigation means what we file or how we say it is, we consider it as a problem or area of some conflict. This is called litigation. Public interest. There are some litigations which we can file on public interest. Generally, why do we go to court? When we are aggrieved or when we are affected or when somebody files a case against us, we will go to court. But sometimes we go to court and file petition not only for our interest but when public interest is affected. So, public interest litigation is a litigation. Public interest litigation is a litigation. PIL is a litigation filed by a public spirited person public interest litigation is a litigation filed by a public spirited person, SPIRITED, filed by a public spirited person who does not have any specific interest in the case. So, listen, public interest litigation is a litigation filed by a public spirited person who does not have any specific interest in the case. Okay, for example, see, if the water of river Ganga is getting contaminated, you won't own river Ganga, but you can file a PIL. Or if there is a problem or any type of traffic congestion for the public, you can file a PIL. Or when Taj Mahal is being discolored, you can file a PIL. So, there are many issues where you can file a PIL though you do not have any specific interest in the case. In America, they are called social action litigations. In America, public interest litigations are called social action litigation, SAL, action litigation. SAL in America, public interest litigation is called social action litigation. Now try to understand. In our constitution, we don't have the concept of PIL. It was not mentioned in the constitution, but Article 32 and Article 226, Article 32 to the Supreme Court, 226 to the High Court, along with other writs, you have the power to file a PIL, you have the right to file a PIL. This idea of PIL was encouraged in 1980s, particularly Justice Krishna Iyer, Justice P.N. Bhagwati. These two judges initially encouraged public interest litigations. Krishna Iyer, P.N. Bhagwati, all these judges have encouraged public interest litigations. Why? In India, first thing, we have huge, massive illiteracy. You cannot expect people to know about their rights. You cannot expect people to have legal literacy. Even we don't have proper literacy levels in India. First is, because of lack of education, all the people cannot enjoy their rights, particularly common rights. This is one reason. Second reason, litigation is very costly in India. To go to court and file a case and run a case is a costly affair in India. So, we cannot expect all the people to run the litigations. And indifference in the sense, people don't bother what happens to the things in common, like water, like roads, like air. There are certain common things which affect the people at large, but people won't bother about that. For all these reasons, we have encouraged the public interest litigation concept. But unfortunately, public interest litigations often is becoming private interest litigation. To take a revenge or vendetta, public interest litigations are being misused. To take a revenge or vendetta, public interest litigations are misused. There are many cases where PILs are filed on frivolous grounds. PILs are filed on frivolous grounds. Frivolous means very uncommon, very remote grounds or very useless grounds. So courts started discouraging these things. In some cases, when court feels that, PILs are found or filed on frivolous grounds, then court started awarding damages, fines. That's called fine. Court started fining the people who filed frivolous time pass PILs. They are called fines for the PILs which are not worthy. Even that the court started doing. So this is what is public interest litigation. I will tell you small examples of the recent cases. Say for example, there is a case called Shriya Singhal versus Union of India. Shriya Singhal versus Union of India. In that case, section 66A of IT Act was declared as unconstitutional. Section 66A of IT Act was declared as unconstitutional. That is a PIL, public interest litigation. And there are Sunil Batra versus Delhi administration. Regarding prisoners' rights, a postcard was accepted as PIL. A postcard was taken as PIL, public interest litigation. So there are many cases where PILs are being filed. You should note it down, all the important cases. And in exam, if they ask you 10 marker or 15 marker about Supreme Court judgments or PILs, you are expected to write. If they specifically ask, illustrate with examples, 3 or 4 minimum you should write. Maximum 5. If I tell 10 cases, that does not mean that you should write all 10. You should take the most important one and most recent one. One is most important one, next is most recent one. Am I clear? Yes. So this is what is PIL, public interest litigation. Who makes? Yes, you can make, you can file. PIL can be filed. Next. Directive principles of state policy. Next chapter, directive principles of state policy. Part 3 of the Indian Constitution deals with fundamental rights. Part 4, DPSPs. DPSP, Directive Principles of State Policy. Part 3 deals with fundamental rights. Part 4 deals with DPSPs. As you all know, we have borrowed this idea of having DPSPs from Irish Constitution. We have borrowed having DPSPs from Irish Constitution, Constitution of Ireland. DPSPs are not enforceable in court of law. DPSPs are not enforceable in court of law. First remember, Article 36 to 51 of the Indian Constitution. Article 36 to Article 51 of the Indian Constitution deals with DPSPs. Article 36 to Article 51 deals with Directive Principles of State Policy. Directive Principles of State Policy 36 to 51. Article 36 defines state, as we have discussed in Article 12. Article 12 of Fundamental Rights chapter defines state. In the same way, Article 36 defines state. The first article in DPSP is Article 36 defines state. S-T-A-T-E, state. Do you remember we have discussed Article 12, state, the same thing 36. We need not want any further discussion because we have already discussed. Article 37. Article 37 says, directive principles are not enforceable in court of law. Directive principles are not enforceable. E-N-F-O-R-C-E-A-B-L-E. Directive principles are not, N-O-T, not enforceable in court of law. That means we cannot go to court when DPSPs are violated. Okay. Directive principles are not enforceable in court of law. Nevertheless, N-E-V-E-R-T-H-E-L-E-S-S. Nevertheless, they are fundamental in the governance of the country. Though they are not enforceable, they are very important in governance. Nevertheless, they are fundamental in the governance of the country. They are very important in the governance of the country. Nevertheless, they are fundamental in the governance of the country. Okay. And Article 38. State should secure effective social order. State should secure effective social order. What do you mean by effective social order? Effective social order means there should be a balanced and equitable social order. State should secure effective, EFFECTIVE. State should secure effective social order. Effective means very balanced, very positive, equitable social order means all people should be happily living in the state, social order should be proper. And state should inform all institutions of national life. What are institutions of national life? Judiciary is the institution of national life. Executive is the institution of national life. All various constitutional statutory bodies are the institutions of national life. For example, Planning Commission earlier, now Niti Aayog. They are non-statutory, non-constitutional bodies. Still, that is the institution which works for good of the individuals. For example, Niti Aayog always has to do research for the betterment of the country. Niti Aayog is an institution of national life. CBI is the institution of national life. Income Tax Department is the institution of national life. They are all the institutions of national life. So, all the institutions of national life should promote the well-being of the country and people. This is Article 38. This is Article 38. Next article is Article 39. Article 39 have various clauses. Article 39 have various clauses. Clause A, B, C, D, E and F. There are Article 39 small a, 39 small b, 39 small c, 39 small d, 39 small e, 39 small f. So, in that few are very, very important for you. Article 39A deals with men and women should have adequate means of livelihood. 39A deals with men and women should have adequate means of livelihood. Adequate means of livelihood. 39A deals with adequate means of livelihood. That means everybody should live with a basic livelihood opportunities. With a basic livelihood opportunities. Now listen, there are two constitution book. There are two articles in the Indian Constitution in the Directive Principles chapter which are considered as core, which are considered as the almost very, very important in our entire setup. Article 39B, 39C, 39 small b, 39 small c. See, forever you should remember these two articles, 39 small b, 39 small c. What does this signify? First listen, then you can note it down. See, the natural resources like mines, minerals, water, trees, forests, fruits, that means the fruits out of them. Don't take in the literal sense, the spirit of it belongs to everyone. See, can somebody say, I own entire minerals in India? No. Iron ore in India? No. So, they can have certain excavation rights, but they cannot own it. In the same way, the economic system of India should be operated in such a way that any economic policy taken by the government should be helpful even to the poor, not only to the rich. Ownership of material resources should belong to all. Operation of economic system should help to everyone. These two articles are considered as very core articles in the entire Directive Principles chapter. Article 39 clause B, 39 clause C. 39 clause D, Article 39 clause D. Equal pay for equal work for both men and women. See, earlier there was no equal pay for equal work, but now equal pay for equal work for both men and women. For both men and women there should be equal pay for equal work. Okay, 39E. See, you will be seeing a old rickshaw puller riding a rickshaw in spite of his 80 years of age. Sometimes because of health and other old age or childhood, all these people will work because they are very poor. Just because of poverty, the children should not be allowed to work in the avocations unsuited for their health. Just because of the poverty, the workers should not be allowed to enter into work which is not suited for their health and age. So these things you should take care of. See, if a man just for lack of food is working in the hot summer, if he is even 70-80 years old, that means our state is not taking care of the old people properly. If the child 10 years old cannot go to school because of poverty and working in the fields and earning 100 rupees per day and helping the parents, that means we are not allowing his childhood to flourish properly. So these things are directive principles where the state has to take care of old people, workers, children, all these people according to 39E. 39F. E. Health and strength of workers. నన్ను కొంతసేపు అయితే మీరు అందరు కలిసి నన్ను ఏదో చేస్తారు. 39F. Health. 39E. Health and strength of workers. 39E. Health and strength of workers, comma, men and women. Health and strength of workers, men and women, and the tender age of children. Tender age of children. TENDER. TENDER should not be abused. Should not be abused. F. Children should be given opportunity. Children should be given an opportunity to develop in a healthy manner. Children should be given an opportunity to develop in a healthy manner. In a healthy manner. MANNER. This is article 39, small a, b, c, d, e and f. Okay. Article 39, capital A. Article 39, capital A. See, whenever capital A appears in the constitution, that means it was added. It was not in the original constitution, it was added. 39 added, A was added. Equal justice and free legal aid. Equal justice and free legal aid. I will explain what is that. First remember 39A, equal justice and free legal aid. Free legal aid, LEGAL, legal AID, aid. Article 40, organization of village panchayats. Article 40, organization of village panchayat. That means panchayat system, organizing the panchayat raj system. Article 40, organization of village panchayat. Okay, next article 41. Article 41. Right to work, comma, education. Right to work, comma, education and public assistance. Right to work, education and public assistance in certain cases. Right to work, education, public assistance in certain cases. Okay. Article 41 deals with right to work, education and public assistance in certain cases. Article 42, provision for just, JUST, just and humane, HUMANE, humane. Provision for just and humane conditions of work. Conditions of work. See, when you work, the working condition should be just and humane. Provision for just and humane conditions of work and maternity relief. You know maternity relief? Women should get maternity leave, all these things. So recently Maternity Benefits Act was amended. Earlier when a woman goes for delivery, she used to get 12 weeks. Now 26 weeks leave. Now 26 weeks leave. Provision for just and humane conditions of work and maternity relief. Article 42. Article 43, living wage. Article 43 deals with living wage. Living wage in the sense, there is a difference between minimum wage and living wage. Minimum, you would have heard the word minimum wage, right? Minimum wage. Minimum wage deals with basic needs, but living wage, living with human dignity. Okay, you should give the wage in such a way that the worker should live with dignity. Next, 43A. 43A, capital A. 43 capital A, participation of workers in the management of industries. 43A, participation of workers in the management of industries. 43B, cooperative societies. 43A deals with participation of workers in management of industries. 43B, cooperative societies. Okay, 43A, participation of workers in the management of industries. 43B, cooperative societies. For Article 44 deals with uniform civil code. Article 44 deals with uniform civil code. What is this uniform civil code? See, criminal laws are same for everyone. Even civil laws are same for everyone, but family laws, Hindu law, Muslim law, Christian law are different. So, to achieve uniform civil code is Article 44's dream, ideal. 44. Article 45. See, before 86th Amendment Act 2002, Article 45 deals with right to education. But after 86th Amendment Act 2002, right to education have become a fundamental right in 21A. So, Article 45 now deals with early childhood care, EARLY, early childhood care. From birth to 6 years, 0 to 6 years, early childhood care, Article 45. And next is Article 46. Do you remember I have told Champakom Dorarajan case? Article 14 versus Article 46. Article 46 deals with promotion of education and academic interests of. Article 46 deals with promotion of education and academic interests of SCs, STs and other weaker sections. Article 46, promotion of education and academic interests of scheduled castes, scheduled tribes and other weaker sections. That is Article 46. SCs and STs and other weaker sections. Education and academic interest, that is Article 46. Next is Article 47. Article 47 says that it is a duty of the state to raise the level of nutrition. It is a duty of the state to raise the level of nutrition, standard of living and improve public health. It is the duty of the state to raise the level of nutrition, standard of living and to improve public health. Nutrition levels, standard of living and public health. Article 47. Article 48. Article 48. Organization of agriculture and animal husbandry. Article 48. Organization of agriculture and animal husbandry. 48. Organization of agriculture and animal husbandry. 48A, capital A, it was added. 48A. Protection and improvement of environment. 48 capital A. Protection and improvement of environment. 48 capital A. Protection and improvement of environment. Safeguarding wildlife and forests. Forests and wildlife. Protection and improvement of environment. Safeguarding forests and wildlife. 48A. Forests, FORESTS, forest and wildlife. Next, 49. Protection of monuments. 49. Protection of monuments. MONUMENTS. protection of monuments and protection of monuments. 49, protection of monuments and places and objects of national importance. 49, protection of monuments and places and objects of national importance. Places and objects, OBJECTS, objects of national importance. Next, 50, separation of judiciary from executive. 50, separation of judiciary from executive. Separating judiciary from executive, 50. 51, promotion of. 50 is separation of judiciary from executive. 51, promotion of international peace. 51, promotion of international peace and security. 51 is promotion of international peace and security. Okay, done. Now read. The last fundamental right, right to constitutional remedies. Constitutional remedies, REMEDIES. The last fundamental right, right to constitutional remedies. Article 32 deals with right to constitutional remedies. Article 32 deals with right to constitutional remedies. Whenever fundamental right is violated, we can go to Supreme Court under 32, High Court under Article 226. Whenever fundamental right is violated, we can go to Supreme Court under 32, High Court under 226. There is no right without a remedy. There is no right without a remedy. REMEDY. There is no right without a remedy. See, when our right is violated, there should be some recourse. Otherwise, there is no use of that right. We can file a writ petition when our fundamental rights are violated. Writ petition means asking the court to give a direction to protect our fundamental rights because they are being violated. Asking the court to use its special powers to direct the executive or any other body to help us. This is called a writ petition. Habeas corpus, HABEAS, habeas, CORPUS, habeas corpus, HABEAS, habeas, CORPUS, habeas corpus, mandamus, 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 quo warranto, QUO, quo, WARRANTO, quo warranto, certiorari, 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 prohibition, PROHIBITION, prohibition. These are the writs: habeas corpus, mandamus, quo warranto, certiorari, prohibition. These are the important writs. Habeas corpus means to have the body, or to produce the body, or to present the body. To have the body, to produce the body, to present the body. This is called habeas corpus. To have the body, to produce the body, or to present the body. Generally, when somebody is illegally detained or when a person is missing, habeas corpus petitions will be filed. And the most important thing here you have to remember, sometimes police will take a person into custody and keep him under their custody without registering FIR. most of the cases where habeas corpus are filed, the victim will be under police custody without being officially detained under FIR. So there won't be FIR, but a man will be taken into police custody. So High Court or Supreme Court will issue a direction to produce the body of the person within a stipulated time to the police, to the state, that is to the state. Generally, to file a habeas corpus petition, victim will not be available. So in place of victim, his mother, wife or best friend, by filing an affidavit can say, this man is missing, I am related to him, so I want his body, because protecting the man is a duty of the state. So this is an extraordinary protection method for the individual. This is called habeas corpus. Habeas corpus means to have the body. When we can file? When a man is missing. Generally, why he will be missing? Generally, most of the times he will be taken into police custody, and police will not register any FIR. Then who can file the petition habeas corpus? By an affidavit. Generally, victim will not be available to sign it. So by an affidavit, victim's relative will be filing, because victim's relative will also be the affected person. So for all these reasons, habeas corpus petitions will be live. Particularly illegal detention. It's a duty of the state to protect the individual. For that reason, habeas corpus petition is the most important for our life and liberty. Article 21. Okay, just remember, this is called habeas corpus, to have the body or to produce the body. Okay, second is mandamus. MANDAMUS. Mandamus means we command. We command means, see, mandamus can be filed against a public authority or quasi-judicial authority. Mandamus can be filed against a public authority or quasi-judicial authority. QUASI, quasi-judicial authority. See, mandamus cannot be filed against a private person for a private obligation. For example, your friend have taken 10,000 rupees from you. He has not paid. You cannot file mandamus against him. Or your friend have promised that he will come to picnic or tour along with you, but he has not performed. You cannot file mandamus. Or A promised to marry B. B cannot file mandamus. So these type of private obligations cannot be filed in the mandamus petition. The duty must be public duty. For example, X is an officer who has to give caste certificate. He has not done his job, so you can file. Or Y is a government authority to oversee the road contract. He has not done it in a proper way. You can file mandamus. So the duty must be public duty. The authority against whom you are filing mandamus should be a public authority or quasi-judicial authority. Quasi-judicial means the authority having certain functions of judiciary, acts like judiciary but not truly judiciary, like National Green Tribunal is a quasi-judicial authority. Okay, so you can file mandamus only against public authority or quasi-judicial authority. The duty must be public duty, not a the duty must be public duty, not a private obligation. And more importantly, before asking the writ of mandamus, there should be a demand and refusal. You should have in writing, you should have asked the officer for your work, but he has not done it. Okay, and more importantly, mandamus can be to do a thing or to stop doing a thing. It can be for two ways. Mandamus can be issued asking the officer to do a thing which he has not done, or to stop to do a thing which he is not supposed to do but he has done it. So mandamus can be in either way. For example, you are the RDO, Group 1 officer. You have issued a notice to a land, government land, supposed to be a government land. A private individual says that land belongs to him, and you have illegally given a particular thing. In such cases, in High Court there can be a mandamus. To stop till the court disposes the property dispute, you should not usurp the land. So even these things you can have a mandamus. Okay, and remember, here I wish to tell you a point. The writ jurisdiction of High Court is wider than the writ jurisdiction of the Supreme Court. The writ jurisdiction of High Court is wider than the writ jurisdiction of the Supreme Court, because Supreme Court can issue writs under Article 32 only when your fundamental rights are violated. When your fundamental rights are violated, Supreme Court can issue writs. Whereas not only when your fundamental rights are violated, even when your legal rights are violated, the High Court can issue writs under Article 226. Okay, I'll give small example. In the previous example of mandamus, I told you about a land, RDO have given notice to a land. Right to property, is it a fundamental right now? No. It's a legal right. So when your legal right is violated, you can file a writ, you can file a writ petition in the High Court, but not in the Supreme Court. So the writ jurisdiction of High Courts are very, very wider, because when your fundamental right is violated, you can file a writ in the Supreme Court 32. Not only when your fundamental rights are violated, but also when your legal rights are violated, you can file in the writ in the High Court under Article 226. So mandamus means, first thing public duty, second thing public authority, third thing not private obligation but public obligation, fourth thing he might be quasi judicial authority also. He might be quasi judicial authority also. Next thing, before asking for writ of mandamus, you should have demanded it and they should have refused. The authority should have refused, the authority should not have been done, should not have done that. And more importantly, mandamus can be to do a thing or to stop doing a thing. This is called mandamus. Am I clear? Next, quo warranto. QUO, quo, WARRANTO, quo warranto. Quo warranto means by what authority? Quo warranto means by what authority? Quo warranto means by what authority? Listen. If a government authority, public authority is holding a post without having the necessary qualifications required to hold the post, without having the necessary qualification required to hold the post, then a writ of quo warranto will lie. For example, an army chief is holding the post, though officially his age was crossed. There might be some manipulation in the age. Or a medical superintendent is holding the superintendent post without having the doctor certificate in a proper way. Or say a public prosecutor, government appointee, is holding the post without having proper legal certificate. So anything, age or necessary qualification, anything for the post, if you do not have that, quo warranto will lie. Quo warranto will lie only against a public authority holding a public post, and the post must be substantive in nature, not ad hoc. Ad hoc, ADHOC. Ad hoc means temporary. See, if X, an officer retired, some other officer on a temporary basis for 1 month post in the post. Quo warranto will not lie on temporary officers or ad hoc officers when government makes some stop-gap arrangement. Okay, it is only for substantive post, permanent post, and it is only for public authority. For example, you cannot file a quo warranto on Infosys Narayan Murthy. You did not possess particular qualification to run a company. Remember, quo warranto is against only public authorities, public post. Okay, quo warranto when the man holding the post should not have possessed the qualifications required for the post. Then you can file a quo warranto. Am I clear? Next. So first is habeas corpus, second is mandamus, third is quo warranto. Next, certiorari. 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 What is mean by this certiorari? See, certiorari is a writ, is a direction given by the higher court to the lower court that its judgment is bad, it should be completely quashed. Okay. On what grounds the higher court gives a direction to the lower court? Judgment. When the judgment is based on error apparent on the face of record, ERROR, error, APPARENT, apparent on the face of record. When the judgment is based on error apparent on the face of record, RECORD, record. Okay, that means when the judgment is erroneous, or when the judgment is based on fraud, when the judgment is based on mistake, fraud, 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 mistake, or when the judgment is against principles of natural justice, or when the judgment is against the principles of natural justice, or when the judgment is given by the lower court without jurisdiction, want of jurisdiction, lack of jurisdiction, or excess of jurisdiction. Want, WANT, want of jurisdiction, lack of jurisdiction, or excess of jurisdiction. On all these grounds, if the judgment is quashed by the higher court, if the judgment is given by the lower court and quashed by the higher court, it is called certiorari. It is called certiorari. And next thing is prohibition. When the judgment is banned in between, on the same grounds, if the higher court stops the proceedings in between, before the judgment is given by the lower court, it was on the proceeding stage, trial stage itself, when it was stopped, it is called prohibition. PROHIBITION. So, on the similar grounds, when the judgment is not given, still the trial is going on. If the higher court stops the proceedings in the lower court, because higher court thought that the judgment is not right, the trial is not being conducted with proper evidence, then you can stop in between. That is called prohibition. So, we have habeas corpus, mandamus, quo warranto, certiorari, prohibition. These are all the writs.